Welcome back. It's still the morning brief right here on Channels Television, and we're continuing with our conversation on medical negligence, of course, engendered and brought to the fore following the very tragic death of the son of renowned author Chimamanda Ngozi Adichie. And today we want to look at the legal aspect or implications, if you like, of this particular event, which has also elicited conversations from others who have experienced similar fate at the hands of some medical practitioners. And so joining us on this particular segment, we have Mr. Dayo Famsville. He is the chairman, Nigeria Bar Association, SBL Committee on Health. He joins us virtually on the program. Good morning, Mr. Famsville. Thank you for joining us on the program.
Good morning. And by way of correction, my name is Mr. Dayo Adu of Morum Africa. And I'm here in my capacity as a legal practitioner, although I also double as the chairman of the MBA section of Business Law Committee on Healthcare and Pharmacy, just to make that clarification.
Okay, Mr. Dayo, thank you so much for the correction, and pardon me, please. And so, as we begin, help us understand what would be the legal intervention should this case go to the MDCN, that is the body that it has the mandate to prosecute cases of medical negligence brought to it. What should be expected, and what should be the legal implication that will come through as a result of it?
So we take it from the context of whether a petition has been filed with the Medical and Dental Council of Nigeria. My understanding is that a petition is not, as of today, is that a petition is not before the Medical and Dental Council of Nigeria. But let's assume that there's a petition. Under the assumption that there's a petition, the first step would be that the doctor or the respondent in this instance will be given an opportunity to respond to the complaint. They have a constitutional right to fair hearing, so they must be able to make their representation as well. Should a prima facie case be established, then they would be, the matter would then proceed to the Medical and Dental Council Tribunal. And the Medical and Dental Council Tribunal has, their status is equivalent to that of a high court. So whatever decisions emanate from that is, in the eye of the law, is seen as a decision of the high court. So whatever remedy flows from there as well will be to the Court of Appeal, should the matter be decided, perhaps in favor of, or against, as the case may be. So a complaint is currently not before the Medical and Dental Council of Nigeria. But notwithstanding, when you look at the MDCN laws, there is actually nowhere in the law where it says that you must bring a petition. I read that law thoroughly. There is actually nowhere. So even the MDCN so moto about their own volition, due to the nature of this matter, the level of public interest that this matter has generated, can also investigate this matter should there be any, because the law is silent on the procedure as well.
Well, now this has raised other issues because you have people now coming out to say, well, I had similar experience. In fact, I'm still affected till date. So when you see the thread, it's almost like something that is consistent, and there's really been no punitive actions taken. Well, before that, proper investigation, right? Maybe a petition put forward, investigation, and punitive actions taken if they are deemed fit. So I want you to speak to the culture first, because for some people this may seem alien. They say, no, don't worry, it's an act of God. Just forgive and forget, let it slide. These things happen. It can happen to anyone, right? If it had swung the other way, you wouldn't have said anything. So really, what is the culture in Nigeria about petitions like this, following things like this through, and getting justice? Is it a thing, or it's basically swimming against the tide?
Yeah, I think we need that cultural sensitization. It's clear that we need that cultural sensitization. And the guilty, the patients as well. It's very important that they're enlightened about their rights. I also think there's a gap when it comes to medical legal training as well, continuing medical education, perhaps in collaboration with lawyers or legal bodies as well, would help doctors to be much more informed as well as to their duties. Not to say they do not take courses in medical school around medical legal concerns, but we need that continuous medical education for doctors. For patients, it's also about them understanding their rights and understanding that the standard of care that is expected of the standard of care that they deserve and that is their rights must be strictly adhered to. I am a bit, I've been seeing all those threads as well on social media, and I think that the medical profession in itself, they probably need to look internally and look at themselves, look at the mirror as well. We know that funding is inadequate. We know staffing in hospitals are not what it should be. We are all aware of what is happening with the Japa syndrome. In some cases, maybe very few cases, we have a few specialists that are now looking back and coming back to Nigeria to set up specialized practices to attend to the needs of patients. But a lot still needs to be done, especially from the point of ensuring that hospitals meet the standard sets by the regulatory agencies. In this case, as in Lagos, for instance, FMR. And perhaps we should probably even also, I know there's a pending bill before the National Assembly that's called second reading. It's on the National Health Facility Regulation, National Health Facility Regulation. And that bill has passed second reading. It's going to public hearing stage. And I would expect that there should be a lot of sensitization. Because if we have national standards in place, then it just goes to say that every state in the federation would try to fall in line with that. As we speak today, only 2 states in Nigeria have any form of facility monitoring agency, and that's Lagos State and Yobe State. So you can imagine that states do not have a compliance mechanism to monitor health facilities. Almost 90% of states do not have that. Although typically in some cases, in most cases, what we have is a situation where the state Ministry of Health have that responsibility to ensure that compliance is the standard of compliance by the hospitals and these health facilities are standard enough. However, it is not enough in this day and age that we do not have a facility accreditation monitoring agency across all states and even at the national level. But I imagine that second reading, that's progress. I imagine that within a few months, we'll probably get this over the line. But the public hearing stage of this is very critical in ensuring that we have a robust legislation that would eventually set the standard across. For patients' rights, I think we need to also have that enlightenment in place where patients need to know that if they are not satisfied, they should also do their own findings as well. That's one of the things. I don't think anybody is insulated from the issue of care. When you are getting good care, I think to an extent you would know as a patient. And if you feel something is off, you need to speak up and ensure that your complaint is also registered. The hospital or the doctors have a duty to keep proper records as well. So it is very important that you speak up, that you understand the treatment plan that the doctors have set out, that you understand and do your own research, because ultimately it's your life that have the protocols in place. But and where there's a need, get second opinions, get third opinions. You just have to be enlightened, self-enlightenment, and also ensuring that you exercise your rights to get opinions from other experts as well.
All right, Mr. Dyer. So let's talk about some of the acts that are in the country that I don't know whether it's been applied. So you mentioned something quite fundamental, and that has to do with, as a matter of fact, ignorance and desperation makes us vulnerable when we find ourselves in those health situations. You just want to get treated. You just want to stay alive. So talk to us beyond this particular case. I want to use the opportunity that we have here who has that background and understands the things around medical practice as a lawyer. Because we're still hearing complaints sometimes about people not being treated, but the hospitals asking for maybe deposit or monies and all of that. What does the law say as at today? If you walk into a hospital and these kind of things happen, how does the law protect you and also protect the health institution who are also businesses in that sense?
Yeah, so we have the national health legislation. There's the National Health Act that states that 1% of funds in the consolidated revenue account must be set aside in a basic health fund. And once these monies are set aside, they are supposed to be deployed. We also have a National Emergency Act as well, where for whatever reason, where there is any accident at any point in time and a patient is rushed to the hospital is expected to commence treatment without hesitation, and they can then claim back their fees from the national, from the basic fund that is set aside by the Ministry of Health. That's a national legislation. It's not a state legislation. What I would expect is that other states try to also have such policies in place, because we are not even sure whether these monies have been remitted to that fund, and we are not even sure. I'm sure private practitioners too are not even enlightened. Private health experts are not even enlightened as to whether the process or the guidelines to access these funds as well. So you will struggle. I've done my own little survey and analysis, and you will struggle to find medical health facilities or practitioners that have been able to access that fund. So the law is there. The guidelines are also there. However, in practice, we are in the dark as to whether these funds are accessible to private health practitioners or otherwise. So you might see a situation where there's an emergency and they are rushed to the hospital, and government hospitals, I know, would definitely attend to patients in dire need. But private health facilities, they'll be concerned about their costs, and that should not be the case. So we need to simplify that access to that fund. There has to be clarity around it. The guidelines must be clear, and health facilities must be well informed about how they can access that fund. States as well, state governments are also expected to probably adopt a similar mechanism and try to ensure that they have a similar legislation or guidelines, as the case may be, so that private health facilities can also enjoy that patronage, and they will not have to depend on the federal purse for that purpose.
So I'm particular about, what patients often say in cases that turn awry and go to the MDCN, and what comes through is, sanctions that are mere slap on the wrist for, in this case, the erring medical practitioner. And so I just checked and saw that the MDCN does not have prosecutorial powers. So in such cases, what options are open to a patient who has perhaps lost a limb or has, had their life altered, and the recommendations from the MDCN is not, addressing the subject, in this case, justice has not been seen to be done. So what options are open to such patients?
Yeah, so the MDCN they are essentially responsible for licensing doctors. And I think another thing is that the healthcare system should be taken holistically. We can't just narrow this down to just doctors. We have nurses, we have pharmacists as well, we have medical laboratory scientists as well, and they all have their respective councils as well. But speaking to the MPCN directly, there's a process, like I said, there must be a complaint, there must be fair hearing given to the respondent, and an investigation is carried out. And it's subject to that investigation, where a prima facie case is established, then the matter is moved to the tribunal. The tribunal has an equivalent jurisdiction like the high courts of states, and currently the tribunal is set up as well. There was a time the tribunal was not properly, was not even constituted, and you can imagine how matters relating to negligence would have just been held on. But now the tribunal is constituted. Once you get to the tribunal, essentially what the tribunal does is for discipline of doctors. Then when it now comes to issues of damages or issues of compensation, you have to approach the state high courts, which has jurisdiction on civil matters that pertain to patients' rights as well. But in establishing medical negligence, the threshold is quite high. There are 4 elements that you must ensure that you are in a position to prove. There's a duty of care, which means that the hospital or the doctors or the medical team must ensure that they meet the expected standard of care to the patients. Then we have now what typically must be present as well is that you must be able to establish that there was that breach of duty of care. And the duty of care is expanded to the extent that the doctor must be skilled, the doctor must be diligent. So where there's a breach of that duty, then you have ticked 2 out of 4 elements. Then we have the causation. If, for instance, like in this case, sadly and regrettably, so the patient passes on, you must be able to establish that the breach of duty of care is what led to the outcome.
Yeah.
Very critical.
Indeed.
That causation element is the most critical. Then the damage. What was the damage that was done? Was it, okay, you lose a limb, you do this, but the breach of duty of care must be clearly established for you. And it's a situation where you have 2 out of 4. It's 4 over 4. All the elements must be present for you to be able to establish your case.
It appears a very tightrope indeed, and more than ever before, more than anything else, perhaps it's more important to stay alive than even approach that tightrope. We must anchor the conversation at this point, and thank you very much. Mr. Dayo Adu is the chairman, NBA SPL Committee on Health. Thank you for bringing your expertise.
I'm here in my capacity as a legal practitioner, not in my capacity as chairman.
Indeed, indeed, you've established that time and again, but both are true of your experience. Thank you, sir, for coming on the program. And when we return from this break, it will be time to talk sports. Are you ready for our next encounter with Morocco? We'll have Puja joining us to bring us up to speed with what is going on in the camp and, of course, talk about all the possibilities. Stay with us. We'll be right back.